I'm going to be speaking to you guys today about how to avoid probate court. So I'm really talking about estate planning and probate. Our firm, Axis Law Group, we only work exclusively in estate planning and probate. Okay. Kristen Kelly, she's our managing attorney. This is her firm. She lives in Missouri. She went and opened up a Missouri branch, but she still owns this branch. Well, I guess I should say the Colorado branches. We have a couple offices here in Colorado. Nice. We have one in Colorado Springs, and we have one in the Denver Tech Center. And we're expanding up north. We're also trying to open one in Pueblo. Lucas Green, he is our newest attorney. That's me. Lucas Green, he's our newest attorney. He is actually the person that's in charge of expanding down in Pueblo. I'm the person in charge of expanding up north. Okay. Okay, there we go. Okay, so I'm going to talk to you about the estate planning process. Okay, there's usually a lot of misconceptions that come with estate planning, and so please feel free to interrupt me, ask a question whenever you want, okay? Very informal setting. So our estate planning process is we have the initial consult with you. This is where we're going to discuss your goals, your concerns, your questions. I go through what I call an estate planning 101, which you're kind of going to get today, but I go more in depth into how it's specifically would work with your goals and your family. But the initial consultation, we get all of that information. At that meeting, I give you a questionnaire, and the questionnaire is going to ask, who do you want in charge in these roles if something happens to me, happens to my spouse, so on and so forth. So this is what we call your power people. Who do we want to be your trustee, your executor? Now that's changed. Executor is a common word that people know, but now it's called personal representative. And I'll get into those details soon. We also go over the zombie apocalypse. That's our nice way of saying what happens if everybody's gone, okay? We know in a full zombie apocalypse, the government would still exist, and they would want your money. And we don't want them to have it. So we like to put in a church, a charity, a nonprofit, something like that at the very end, just in case. And then we go over rules for distribution. So how many people here have children? How many of you have minor children? Okay, how many of you have rental properties? Okay, how many of you own a business? Okay, it's easier for me to cater to what I'm going to be talking about today. So, rules for distribution. If we have minor children or minor beneficiaries, if we have grandchildren that we want to provide for, we can't just give a minor money. They have to be at least 18 years old. So, this is when we talk about what age do you want your beneficiary to be to receive 10%, 50%, however much, right? You can distribute, make distributions at different ages, things like that. So that's what we talk about for rules for distribution. There are other sort of distribution restrictions you can place. We have some clients who come in and they're worried about their beneficiaries' alcohol addiction or drug addiction. If we have some sort of concern for giving a large lump of money to somebody, we can put certain restrictions in place to make sure that they'll be a little bit more responsible with it, okay? After that planning meeting and I get all of the information that I need, I will be drafting all of your documents. Something that Axis Law Group does that a lot of estate planning attorneys don't do is we draft our own plans. So a lot of estate planning attorneys will just pull templates from online. You'll get like a 90-page trust. You have no idea what it says. That's not what we do here. I have some clients who come to me and they have, again, a 90-page trust. This is not an exaggeration. And then I'll say, why don't we just restate this and you'll have a 17-page trust. And they're like, yeah, that sounds great. And then you'll actually know what it says. They're like, that's a great idea. So it takes me about a week, sometimes two, to draft your documents. And then we bring you in for your signing meeting. Your signing meeting is your longest meeting, but this is where I walk you through all of your documents. Yes?
You said there's like the online stuff and then you've done your own. is it customized to each person, family, or business, or is it something that you drafted yourself and it can cover pretty much everybody depending on their situation?
So there are certain provisions that cover everybody's plan.
Right.
But when it comes to your actual distribution, that's something that we do differently for everybody, depending on what the goals are,
Cool.
who we're distributing to, things
Sure.
like that.
Thank you.
Yeah. So signing meeting, I go over all the documents with you, make sure you understand what everything says, how it works, everything looks right, you still feel comfortable with it all. Then you sign, I notarize and provide witnesses, I record deeds on the property that day, so everything really becomes official, very easy for you at the signing meeting. And then we have an optional fourth meeting. This is a complimentary meeting that we provide to our clients, and it's where I can speak with your power people and let them know, what does this plan say, what does it mean. I go over really important things like don't open a probate, okay? This whole seminar is going to be talking about probate court, why we want to avoid it, and how we can avoid it. So all of the plans that we create make sure that you avoid probate. And the last thing I want is for something to happen to you, and then someone goes and opens an unnecessary probate that we can't close until the 6-month point. We have to go through the entire probate process once it's opened. So I'll get into that as well. But I go over that. Inheritance is not considered marital property, so if you're worried about an in-law getting money and things like that, I talk to you about that. There's no inheritance tax. People are worried about inheritance tax. I just generally give people an idea of what it means to be in the roles that they're in. Okay, so are there any questions about Axis Law Group process for anything? Okay, so what pulls an estate into probate? So probate is the required court process that happens when someone passes away. There are two things that trigger a probate, or when a probate is required. One of them is if you have assets, and now it's $82,000 or more in total assets. So that's all of your financial accounts combined. Checkings and savings, life insurance policies, right, 401ks, anything that you have.
And that's for like nationwide?
Yep. Yeah, any financial accounts, yes.
What is the exact purpose of probate, other than the government sticking their nose in your business?
Yep, so that's a good question. I think the easiest example to explain that is, one of them is for if you own real property, right? So if you own real property, so a house, then it can trigger probate. So if me, Nicole, if I own a house, on the title it says Nicole DiArpa owns this house, I die, who has the authority to sell it?
Right.
So is it without a will or stuff, the paperwork that you would have, then the government says, well, we're gonna have to determine this and we'll do it at your expense.
So the will actually acts as an instruction sheet for the probate process.
Okay.
A lot of people think if I have a will, then I'm good to
It
go.
doesn't avoid probate.
No,
just
no, no.
for will.
It just tells the court who to appoint.
Mhm.
So so the probate process, to answer your question of what is it for, it's to officially appoint somebody to act on my behalf when I've died. Yes.
Speaking of a will, I've been told, and correct me if I'm wrong, if you have life insurance, if you have bank accounts, if you have a retirement account, whoever's the beneficiaries on those trump anything a will says anyway.
It is. Yep.
Okay.
That's true.
So, but you should have them matching ideally.
Ideally, but I'm going to also walk you through the difference, especially if you have minor children, because we don't want to put minors as beneficiaries, but we want that money to go to our children. If you name, your brother or your sister as a beneficiary, and you say, use that money for my kids, that is not what I would recommend to do, because one, your brother or sister does not legally have to use that money for your kids, right? I'm not saying that they wouldn't, but it'd be very easy for them to take a little bit to use for themselves, or not handle it the way that they should be. The other thing is, what if your brother or sister predeceases you and you don't update your beneficiary designation? Now that account has triggered a probate. So there's a lot of, it's going to depend on your goals, where you want things to go for me to talk. I always talk through beneficiary designations, but when it comes to who we're naming, that's very important.
Okay.
But yes, it does trump a will. Yes. You got questions answered? Okay, good. I was gonna make sure I covered everything. Okay. Okay. So probate. Just I don't know how to go back from this. Oh, there we go. Okay, great. So probate, those are the two things that require a probate. So there are There's a difference between probate assets and non-probate assets. To give you an example, we had a client who her and her husband came in about 3 years ago. They got a plan, it avoided probate. Husband just recently passed. She forgot that she did not need to go to probate. She went and opened a probate in the court on her own.
Oh.
Then she contacted us, and I said,
Oops.
now we have to go through this probate process. But there are no probate assets. The house is in her name. She doesn't need to wait on the probate in order to sell it. There's nothing that needs to go through there's nothing that she needs letters of administration or letters testamentary, which is what you get when you're officially appointed as a personal representative. There's nothing she needs to do that because there's nothing that's actually triggering probate. So I just have to do all of the statutory requirements for her, like publishing in the newspaper, waiting the creditor deadline, sending notice, things like that. I just have to do that. Whereas if when people need probate, they come to me and they say, I can't sell this house because my dad died, I need to sell this house, what do I do? The way that probate process works is I have to file all of the open probate documents, then we wait until they get officially appointed. That varies. It varies on county, it varies on how many people are opening probates, things like that. We usually give people about a 4 to 8 week period. We say this is what you're going to wait before you get appointed. So then we just wait. Then they get appointed and they get letters of administration. It's also called letters testamentary. It depends on if there's a will or if there's not a will. But they get those letters. Those letters is what gives them the authority to now go sell the house or contact the bank accounts, or now people will speak with them. If they just go to a bank or go to a realtor and say, look at this will, I'm appointed, the realtor needs to say, I don't care. I need to see a court document that says you're officially appointed, right? So probate process has to be open for at least 6 months, and it's costing anywhere between $10,000 and $15,000. It's very expensive. It's very timely. It doesn't usually close at the 6 month point. Now the client that came in who doesn't have anything that's going through probate will be able to close at 6 months because nothing's actually going through probate. How long does it take to sell a house? How long does it take to get financial institutions to get all the paperwork done and transfer the money, do all of those things? It takes a lot longer than 6 months. So sometimes probate takes longer than 6 months. But this is why we want to avoid probate. Okay? So the way we avoid it is having a proper estate plan. So I'm going to talk to you about wills and trusts. These are really the two main roads into estate plans. So in a will, you choose a power person. Again, this used to be called an executor. It is now called a personal representative. It is the exact same job. They just changed the terminology to confuse everybody.
Right.
In a will, you decide where things go. Okay, so that's why usually when people say I have a will, I'm good to go, it says where everything goes. Well, that person needs to get appointed in the probate process in order to distribute those things in accordance with your will. You have to appoint guardian for minor children. So some of you said that you had minor children. This is very important. While you can and will avoid probate going through with us, you cannot avoid a guardianship hearing. So if something happens to you and your spouse and you have minor children, the state has to get involved to officially appoint a guardian for your minor child. But that provision in your will expedites that process. Okay, so if the guardian that's appointed in your will is more likely to be able to keep the child before the hearing, because some kids end up going to foster care while they wait for guardianship hearings because we don't know who's going to get appointed. We have family members fighting of who's going to be the guardian of this child. It can become very contentious. The will expedites that process. Okay, so while it can't be avoided, it's better to be expedited. A will does not avoid probate, as I've said a few times now. It acts as the instruction sheet for the probate process. So it says to the court who I want appointed and where I want everything to go. Now, if I do not have a will, there is a statute. It's called the intestacy statute. It is essentially the state's estate plan for you. It determines in priority order who would be appointed as personal representative, where things would go. Now, one of the problems with this, I had one probate where she passed and she wrote a will. Okay, there is a statute that allows you to write a will, right? The bar napkin wills that people talk about and things like that. She wrote her own will. She didn't sign it, so it's not valid. So we couldn't use it. And she wanted everything to go to her cousins and to her nephew, right? Like, essentially. She didn't have a will, so it goes to the intestacy statute, which I won't bore you with the priority of appointment. Where everything ended up going was to her niece and her nephew, 50-50. Her niece, it's been very known throughout the family, they don't like each other, or they didn't like each other. I had to call and give notice to the niece and get her information because I needed to put it in the probate documents. And she said, my aunt gave me 50% of her estate. I said, no, she didn't. The state is giving you 50% of her estate. So it is important to, wills are important in, I don't know. Wills are important when it comes to letting everybody know where you want your things to go, because it could very end up with somebody that you don't want it to go to.
And why does that happen? I mean, why does this, they decide that it's gonna go to the niece?
So it goes in priority of appointment. So it goes to your spouse first. If not your spouse, and your kids. She didn't have a spouse, she didn't have kids, or kids passed. But yeah, it goes in order. So if it doesn't go to your kids, then it goes to your parents. If it doesn't go to your parents, it goes to your siblings. If it doesn't go to your siblings, it goes to your siblings'
Like your niece or nephew.
descendants, so your nieces and nephews, right? So it went, all of these people had predeceased her, so it went to her niece and nephew.
Kind of more like priority bloodline versus like cousins and
Right.
All right, so the cousins are on the
Yep.
fringes.
Mm-hmm. That was a good question. Yep.
I have a question. So what happens in the case of, so an example, so like I have a minor daughter who's 15 and I'm a guardian of my grandson legally.
Mm-hmm.
So, and he's gonna be 7
Mhm.
next month. So what happens in that situation with him? So like what steps should I take in the event something happens to me because I'm his guardian? Where does that leave him? I
Same,
guess?
we would be putting a provision in your will that says the guardian for him.
Because I'm the only guardian.
Yep, you'd be putting a backup. Well, have something happen, you appoint somebody.
Okay, so
And
what
then
happens legally though? Like,
There's that hearing, and then that new person that you appointed, that in your will, would be officially appointed by the state to be the legal guardian.
got it. Okay.
Is it called like a contingent beneficiary or something like that? Is there a term?
A beneficiary is someone who's receiving money.
Okay,
They would be a successor guardian.
okay.
Would you want like two, to like a backup to that?
Yeah, I like backups, as many backups on anything that you have. Guardians, personal representatives, trustees, powers of attorney, everything. Put a backup. Yeah. Who would you want to take care of him? If they couldn't act for some reason, who else would you want to take care of him? So on and so forth.
And how much does a living trust run normally for?
Yeah, so our whole plans, because you get a trust and then there's other documents I'm gonna go to if you get a trust, but also with a trust you get a will. But anywhere, you're looking anywhere from 35 to 5,000 for all those documents.
And this, I mean, is it safe to assume that both these documents are ongoing working documents? As time goes on, you can update them and that sort of thing?
Yep, anything can be updated or amended or changed while you're alive. Yes.
Question on that. Yeah, say somebody has one and then now they're like getting elderly and it's like that one cousin who's wanting them to change it or whatnot. You know, how do you protect them from someone saying like, oh yeah, just sign this document, or you know what I mean? Because sometimes how it can get changed and they have no idea.
Yes, yeah, so that's undue influence
Okay.
or coercion. That's illegal.
Right.
But it happens. But it
Yeah.
happens. It does. Yeah, it happens. You know, I would just, if you, one of the I had one probate where the argument was she coerced, was she unduly influenced, and you really want to know if they are in their right state of mind at the time that they signed this document. So if you have a doctor that says she's incapacitated or he's incapacitated, just get that in writing as of whatever date, and then anything after that would be void. I'd say that would be the easiest way for you to not go to court. But another helpful tool is a trust, which is what I'll talk about now. So trusts, they avoid probate, so you'll see that. Trusts avoid probate. Trusts are similar to a business entity or an LLC. It can own property, it can be named as beneficiary on accounts, okay, things like this. And You choose your successor trustee. They do not need to go to court in order to be appointed. A trust, they have immediate authority. Once they have a death certificate in your trust, they can act. They don't have to go to court in order to pay those fees and expenses and things like that. You still decide where your assets go. The beauty of a trust is that you can put in those rules or restrictions and things like that we'll also talk about more in a few slides. It does avoid probate. It grows with your estate very easily, so if you purchase new property, you can just buy that new property in the name of your trust. You don't need to come to me or do anything specific to do that. You just buy future properties anywhere in the United States in your trust name, and it'll avoid probate in that in that state as well. You'll select the rules for distribution, and it protects the inheritance. So another benefit on here that's not listed is privacy. So one of the times we see people kind of coming out of the woodwork, or it's easier for people to come out of the woodwork, is because probate requires notice to heirs. So and so has died. Here's the court process. So what do people do? They hire attorneys. They start, and then it becomes a bigger and bigger thing. Trusts, they get administered. No notice is required, right? Except for, of course, to the beneficiaries. But you don't need to. If the cousin that's coming out of the woodwork's not in the trust, they don't need to know anything that's going on. So it does provide that level of privacy that also helps mitigate the people coming out of the woodwork trying to get that money. Yes.
Does the trust, you just mentioned like the cousin who's out there and they find out all of a sudden that there's some money and they want to try to get some because it's in a trust. Is there any way for them to fight that trust to try to get some of that money?
Yeah, they can go open up a court process for sure.
Okay.
Yeah, they'd have to hire an attorney and do all those things. But usually those people don't want to spend the money on an attorney. to
Right,
get
yeah,
that done.
they usually don't.
Yep. But yeah, they can. Yeah, you know.
Okay.
The beauty of America, you can sue for any reason you want.
Yeah.
Yes.
So real property, life insurance, bank accounts, all that can be funneled through the trust.
Yes.
Okay. Got it.
So with the trust, typically what we recommend is any individual accounts between you and your spouse, you put each other as the primary beneficiary and you put the trust as the backup beneficiary. So that when you've both passed, your successor trustee will now contact those financial institutions and move it into the trust account that he or she opens. And then now we have all that money in one pot right here, and then they can sell property if that's what they're going to do. That money goes into this pot right here. Now we have everything here. From this trust account that they open, they're going to pay expenses and taxes and bill, whatever needs to be paid for, and then they're going to distribute the remainder in accordance with your trust. Now, if we have minor children, and it needs to be, we have 10 years before they receive their final distribution or something, then we take the remainder of this and we work with financial advisors, we make sure it's being invested, we make sure it's growing with inflation, things like that, so that your kids will have that money at the time that they reach whichever age it is that you choose.
So,
Yes.
quick question about bank accounts, because my ex-father-in-law passed away and his accounts were frozen because he didn't have anything, and his biological son couldn't pay for stuff.
Oh, like out of his own pocket, you mean?
Well, he had to pay out of his own pocket, but not out of his dad's accounts
Mm-hmm.
after he had passed. So,
Because he had to open a probate.
yeah.
Yeah. Once he opens a probate, then he'd be able to unfreeze those accounts, take that money, and he would move it into an estate account.
Mm-hmm.
If you're in probate, that'd be an estate account. But when you're a trustee, it's a trust account that they'd be moving into. So he would have to do that. But was there a question?
Well, so in the trust, they're not like frozen. They just keep going.
Right. Yeah. Yes. Correct. Because so long as the trust is listed as the beneficiary, yes. Yeah. So that's really important, is proper funding to the trust. Because like I also had a client who, they were in the Springs and then they moved recently to Firestone, and they called me, they wanted to make amendments, so we do some amendments to their trust. And I said, hey, did you buy your new property in the name of your trust? They said, yeah, I think that we did. I said, why don't you just give me that address and I'm going to pull that ownership report. And it wasn't in the trust name, so I put it in the trust name. So it is important that those, you have to be on top of when things change. You can always call me and I will fix it. But, or just if they called and said, we're buying a house, I forgot what I'm supposed to do, I would walk them through it, because you want to make sure that your trust is properly funded in order for it to do what you want it to do. Yes.
So I've been advised that each investment property you have should have its own LLC ideally and operating agreement. Because if you get sued, then, don't put 5 properties in one LLC, because they'll come after all that money if something happens.
Yep.
And then so if we buy additional properties, do we just tell you, hey, it's gonna be this LLC's name and here's the address or whatever the case may be, and then you just add it to the trust?
So you actually don't need to come tell me anything when it comes to the trust. If you came to me and said, we're getting an LLC, can you draft the operating agreement, then I would do that. But I don't ever reference any specific addresses or things like that in here, unless it's like, unless you want me to, of course. I draft the things so that they are, so that you don't have to keep coming back to me and as you grow your estate, right? So for example, when I have clients who say, I want my primary residence to go to my oldest child, well, I say, well, what if you move? What if your primary residence changes by the time you both die? So I put primary residence to oldest son, right? Whatever that primary residence is at the time of the second one to die, that goes to the son. As the LLC, for the LLCs, your operating agreements need to mention your trust. So if I'm the one drafting it, I'll make sure that that's going on. But if you're doing that on your own, you would just need to make sure that your trust is referenced in the operating agreement.
Got it.
But anything, you really only ever need to come to me to make changes. If if you have a question, like I said, if you're like, I bought an LLC, what do I need to do? I would say make sure it's in your operating agreement. That's really that. Or if I'm buying a new primary residence or a secondary home, what do I need to do? I would walk you through how to make sure it's in the trust name, But you really only need to come to me to make changes if you want to change a trustee or change a power person, if you want to change a distribution pattern, if you want to disinherit a child, if you want to like change something fundamentally about how it's being administered, you come to me.
Stuck around.
Yeah, yes, you can disinherit children.
But yeah, just to protect yourself, call you ahead of time. Just this is what's life events are happening.
Yeah, I had another client, married couple. The wife passed, and the daughter called me, and I can't speak with her because she's not my client, and so I told her that, and she got her dad on the phone, and he said, okay, you can talk to her. I said, great. And she said, I need help opening this probate. I said, no, don't open probate. She said, well, I Googled, and we need probate. And I said, no.
Don't Google.
Don't need probate. I'm so glad you called me. And then I said, come in, and we essentially had the family meeting a year later, and I just walked them through it again. You can get overwhelmed when something's happening, whether it's someone passing or whether you're buying a new property. We know that's overwhelming too. Just give me a call. That's the easiest way to do it, and I'll answer all those questions on what needs to happen, if anything. Any other questions about that?
Well, maybe you can help me answer this. So a year ago, I had a client who wanted to purchase a house here in the trust, and then his daughter, who was taking care of him, so it's his trust, but was like, no, we don't want to sign. She didn't want him to sign because his hands were shaky, and so I was like, all right, well, I can talk, we can do POA and have you sign, but she's not listed as POA in the trust, so she's not, and so we couldn't do it.
Mm-hmm.
Like, he had to sign it.
Yeah.
Or I didn't put it in the trust, and they had to do it later.
Yeah, so, did he have capacity?
Mhm.
Okay, so then, if she just didn't want him to sign because he was shaky, then,
Yeah.
I don't know.
That's lame.
Yeah,
No,
he could have signed.
Like,
if
half
he has
the
capacity.
documents are hybrid, or on the e-sign anyway, so it doesn't really
Right,
matter.
yeah.
But
But to answer your other, what I
part,
think is the POA, is in the trust, our trust, if the trustee or the settlor, so the dad at that point, if he's unable to act, it will fall to the successor. So if she was named as the successor trustee, she would have been able to sign because he's still the beneficiary. So it would have been like if he was incapacitated, like he's not able to act, it would fall to the successor, but he was still the lifetime beneficiary of that trust.
Mhm.
You're still you while you're alive, that all of those assets are yours, even if somebody's acting on your behalf. But he had capacity, so
yeah.
but one of the reasons too we provide powers of attorney with our plans, so that would never be a problem
Okay.
in this situation because everybody, once they get the trust, they also get all the other documents, so that there's no holes. That's why we do it that way.
They have to, yeah.
Um,
After the fact, but.
I'm also going to talk a little bit about protecting the inheritance and the rules for distribution. which goes into the 4 main reasons that we recommend a trust. Okay, so you can avoid probate with a will if you have a beneficiary deed on your property and as long as you have beneficiaries on all of your accounts, right? Because we only use wills if we are in probate. But if we have minor children, we don't want to name them as beneficiaries, like I mentioned before, or we don't want them to receive, large lump sums at the age, like if they're 18, we don't want them to receive large lump sums. So sometimes a will and beneficiary deed is not the best option, and there are also a lot of issues that can come about. I have some clients who they say, I don't need a trust, that complicates things, and I'll say, like, how so, and they'll say, well, I'm just going to put my daughter on the house, right? But they have, let's say there's 3 children. I'm just going to put my oldest on the house. She'll handle it. She'll figure it out. And I say, okay, well, one, if you put your daughter on the house now, she's not going to receive a step up in basis, which is a huge tax advantage. She's, let's say mom purchased the property for $100,000, but when she dies, it's worth $500,000. If the kids inherit it, they're inheriting it at the $500,000 point. If mom quit claims her daughter on here, she's not going to get that step up in basis. She's going to be responsible for capital gains taxes.
On
So we don't.
400?
Yeah.
400, okay.
Mm-hmm. So we don't want that. Yeah, we don't want that. The other thing is that, okay, I'll just put my daughter as the joint owner on my bank account. I don't recommend that you own a bank account with your children. They can take that money. They can kick you out of homes if you own properties with them. They can drain your bank accounts. Again, I'm not saying that your children will do this, but I am saying that children do this. Yeah. And then another issue is if you own the property with an account with your daughter, and then you die, that account is now your daughter's. It's not an inheritance. She just jointly owned it with you. So she has no legal obligation to distribute that to her siblings. It's her money legally. There would be absolutely no recourse. Kind of back to your other question, what recourse would there be? None, because it's not their money. It's not. So it's just easier to do things in a streamlined manner. But for minor children specifically, and the rules for distribution, with a trust, there are mandatory distributions and discretionary distributions. So mandatory distribution says when my child reaches 25, they get 50% of their inheritance. When they reach 30, they get the remainder, right? That's a mandatory distribution. The second my child becomes 25, you give them 50% of what's in that account. A discretionary distribution says that my child's 21, so they're not getting that mandatory distribution yet, but they need some money. They need money for tuition or studying abroad or fixing their car, something like that, right? They can go to the trustee and they can say, can I have $3,000 to fix all this stuff in my car? And the trustee can say, yes, absolutely, here's $3,000 to fix your car, right? But on the flip side, if your child is 21 and says, I need $100,000 for a brand new Tesla, the trustee also has the discretion to say, no, here's $3,000 to go fix your car, right? So the discretion is very large. It's for their health, education, maintenance, and support. Those are very broad, vague terms to allow the most amount of discretion for your trustee, right, to distribute any additional funds. So the 4 reasons we recommend trust: 1 is if you have minor children. 2 is if you own multiple properties. So this will get into the LLCs. So LLCs, I do have clients who come to me and they'll say, okay, I have 5 rental properties. I was told I need 5 LLCs. And I say, okay, well, 5 LLCs is definitely going to provide you the most liability protection. There's no doubt about it. But the Secretary of State does not require an operating agreement. They don't require you to record annual minutes. They just have you file the articles of organization. That's all that the Secretary of State needs. But in order to be afforded the liability protection that comes with an LLC, you need to hold annual minutes, you need to have an operating agreement, and you need to have a business account. So some people say, ugh, that sounds like a lot of work. And I say, okay, if you have 5 LLCs, are you going to manage 5 business accounts? And they say, ugh, it just seems like too much to some people. Then I say, then don't get 5 LLCs, because what's the point? It's not going to afford you the liability protection. We can put it all in one LLC if that's all that you feel that you can manage, and then you're going to meet with an advisor and make sure you have enough coverage, right, over each property. So usually what I do when people come to me with LLCs is I talk to them about what I'm talking to you about now. These are the steps that need to be had for each individual LLC, and some people say that's too much. Especially when some people, I have some clients who have 13, 14 rental properties, and they're like, I don't want 13, 14 business accounts, or, okay, well then we can consolidate some, so then they have 5 LLCs with multiple in there, and they have enough insurance that they feel comfortable. It's whatever I say you feel comfortable doing, but absolutely having one LLC and all 3 formalities met for each LLC is going to provide the most liability protection. It's just that a lot of people don't follow those formalities. And so then it's called piercing the corporate veil. This is the liability protection, when we don't have those formalities, the veil is pierced, and now they can go after personal assets. So that's why I say don't put yourself in a situation to have that happen just because you think you're getting liability protection. With an LLC, the operating agreement is extremely important because you can't put beneficiaries on a business account. So business accounts, they are run by the business governing document, so the operating agreement. So the operating agreement needs to say, I'm in charge of this business, but when I die, so-and-so is now in charge of this business. And you say what their powers are, right? You can say their power is only to wind up the business, close it, and transfer the assets to my trust. Whatever it might be, right? Depends on, I go through like lots and lots of hypotheticals with people who have LLCs. Some of them want the LLCs to continue running and provide income for the kids. Once they reach a certain age, then we put it into the kids' names. There's lots of things you can do with rental properties, but the operating agreement is very, very important because I have had to open a probate for a business account that had less than $5,000 in it. Do you remember that $82,000 threshold? That really doesn't mean anything with the business account. Banks will just lock a business account if there's no governing document for that business. So the operating agreement is very, very important for that. So any questions about LLCs, rental properties, anything like that? Okay. The other reason is the rules for distribution. So maybe we don't have minor children, but again, we have some concerns about beneficiaries, whether they have drug problems or alcohol addiction or anything like that, and we want to put in certain restrictions. That's where those rules for distributions and when a trust would be beneficial. Another thing is if you have a beneficiary who is disabled or is going to be receiving government benefits for their life, we don't want to give them a bunch of money because they'll become disqualified from their benefits. So we do that in the trust as well. So it would, yes.
Have you found with distribution, let's just say there's 3 kids involved, I won't say whose.
Yep.
But let's just say we know their spending habits. And have you found it beneficial that, like I think you mentioned earlier, like certain ages they get a certain percentage because let's say 2 of the 3 are spenders and the other one's not.
Yep.
We want them to, graduate from college, buy a house. Would you agree that's the best and most successful that you've seen with your clients?
Most of the time, what my clients do is they like the first distribution being at the age of 25.
Okay.
They like the second one to be at 30, or the final one to be at 30, and then the third one if they do another one at 35. That is the most common ages that people choose.
Because of life events and that sort of thing?
Because of the life events.
Okay.
Now, I do have some clients who say, oh, I don't know, like, what if they haven't graduated, or whatever their certain circumstances are that we're worried about, then we do it based off of achievements. So you can say first distribution is upon graduating high school or college, trade school, whatever, community college, something like that. You could, you could say it's based on achievements, and that's when they get the distribution. You can also say, though, for example, I have some clients who they're like, okay, I want their first large chunk to happen at 25, but my client's a business owner, and they said, well, but if my kid is 20 years old and they want to open up a business, I want them to have the ability to get some money to open a business. So then we could put in there that so long as they're 20, they can receive up to X amount, provided they give a business plan and all of these things to the trustee, then they can receive that money for a business, right? Or for buying a house. That's a common one too. They can get 10% if they are this age and they want to purchase a home or whatever it might be. So you can do all of those things.
Okay. Thank you.
Mm-hmm. And if we have 3 kids and we have 1 that we're not worried about, but 2 that we are worried about with spending habits, you can do different distributions for children. People don't really like that. That's not common, but you can do that. Yeah, people like to keep it the same.
Even,
Yeah.
yeah, that's great.
Yeah.
I don't want to start a war.
Yeah, the only time it's usually ever drastically different between kids is if we have like one has is in and out of rehab and the other is something like that. Then it's different, and there's not much you can really do to with that. But and then the fourth is business owners. So I know some of you also own a business. I just talked about this with the LLCs. Those are businesses, but even if you have just a business where you provide a service or something like this, you should be having governing documents with that business or for your business, and it should say what happens when you pass, who's going to be in charge, who's going to be given access to your business account to pay any employees that you have, or to wind it up, or to transfer it to your trust, things like that. So if you're a business owner too, we're going to recommend a trust. Are there any questions about why we recommend trusts, or okay? Okay, so other documents that come with an estate plan are powers of attorney. So these are very, very important and extremely underrated. Powers of attorney are used if I am still alive, but if I'm not able to make decisions for myself. Okay, so a lot of people jump straight to coma, but more commonly this is if I have a stroke, if I have a brain aneurysm, if I have dementia. So I could be up and moving, but I don't know what's going on. So a doctor says somebody needs to be making decisions for Nicole. That's where powers of attorney come into place. If I don't have a power of attorney in place and I become incapacitated, I have to go through a guardianship conservatorship hearing. This is a one-day hearing that can cost anywhere from $10,000 to $20,000. Very expensive, okay? Your spouse does not have immediate authority to act on your behalf, okay? So that's also another common misconception, is that something happens to me, my husband, he can just act on my behalf. No, because unfortunately we have some spouses that don't do the right thing for insurance money or for whatever the reason may be, right? So if you don't have powers of attorney, these are very important. Usually you appoint each other first, and then however many backups you feel comfortable with. There's financial power of attorney. This is the person that's going to make sure that your bills are being paid, your groceries are being purchased, your taxes are being filed, anything that needs to be paid for. They are given access to your accounts so they can pay for things. Medical power of attorney, much more broad. Any medical decisions they're going to be making on your behalf. Okay, so it is important that your medical powers of attorney know what your wishes would be, because if they were the ones in charge, they're calling all the shots. Okay. Additional protections for these are disability insurance and income protection policies. So I've also been getting a lot of questions about long-term care insurance. Mm-hmm. So if you're worried about if something happens and how are we going to pay for those things, you can always meet with an advisor and discuss long-term care insurance or any of those policies that might be beneficial for you. Okay, you also get a living will. This is also called an advance directive. It is not a will, number one. It is a medical document that says if two doctors both agree that I'm in a persistent vegetative state, how many days would I want to be on life support? Okay, so this is really important because it would be taking that decision out of your loved one's hands. We don't want the guilt and confusion to overwhelm our loved ones if we were in this sort of situation. So here you choose the number of days. I walk you through that document very clearly. This is also different from a DNR. I get that question a lot. This is not a DNR, like if I get a heart attack, if I have a heart attack, or if I get into a car accident, don't resuscitate me. That is a medical document that can only be filled out with doctors. Okay, it's called a MOST form, M-O-S-T form. But this is only if I'm in a vegetative state. So no brain activity, I'm not getting better, I'm prolonging the dying process with keeping these machines on. I choose how many days until I'm removed from the machines. Any questions about an advance directive? Okay, so the whole plan. So this is just a little funny thing. I keep having this nightmare that we don't spend the money and time and the kids inherit it all. I am a big proponent of it is your money. Okay, I tell my parents, go spend every last cent. This is your money. And I tell my clients the same thing too. Okay, now if we have minor children, obviously we have a little bit more to be thinking about, but as we get older, just remember it's your money. Now, estate planning is more than just the document. So beneficiary designations, that is something that I walk people through in depth to see And that's part of your planning meeting. I'm gonna see where your accounts are located. I don't need to know how much you are worth or how much is in your accounts unless you individually are worth more than 13.61 million, or if you and your spouse are collectively worth more than 27.22 million. Otherwise, I'm just looking for organizational purposes to make sure you have the proper beneficiaries on all of your accounts. Home and asset ownership types are extremely, extremely important. I had a client come in, his wife passed, so he wanted to get his estate plan. So we do his estate plan. I pull his ownership report, and him and his wife owned the property as tenants in common. Are we familiar with the tenants in common and joint tenancy?
Yes.
Joint tenancy would have meant that when she died, he owned the property all on his own. Because they owned it as tenants in common, her 50% of that home needed to be go through probate. So we finished his estate plan and had to immediately go open a probate to get that 50% into his name to then put it into his trust name. But now his kids will not have to go through probate when something happens to him. So home and asset ownership types are very important. I also have a lot of people who love to do their own quitclaim deeds. Stop doing your own quitclaim deeds unless you work in, title or work as your real. Unless you understand, nobody should be doing their own deeds. I've had way too many clients. Yes.
We can get a title company to do it though.
Yeah.
Correct? Okay.
But you want to be.
Right here.
We actually now, because of liability, we recommend that. Well, our company won't actually inherit, but we'll help you. So we'll get a sample. We'll have a blank one for you, and then I'll have tips of what you're supposed to put. But legally, which we actually will recommend an attorney if anything, because
That's
you
great.
can't go and do it by yourself. Because since we're not insuring the property when we do that, we're not going through the whole process. We just want to make sure there's no hidden liens or something that might pop up, because then they're going to come at us, and it's just one of those just kind of cover yourself thing. But we can definitely help you with it.
That's a great call. Honestly, I love hearing that they're recommending attorneys. I think that attorneys should be the only ones that can record these. When we have probates, title companies, they won't draft personal representatives deeds. An attorney has to. So some people who they'll come to us just needing a personal representatives deed in the probate. They've already gone through the whole probate process, but they're like, I need an attorney to draft this deed. The deeds are so important. We pull the full chain of title. We make sure. I had one client who he was quitclaim happy. He quitclaimed 19 deeds. And if you think there was more than one error, there was. And so when there's an issue, it messes up the chain of title. You'd have to be like, this one's void. This would be the next one. This one's invalid. And you have to, it's a mess. So home and asset ownership types are extremely important, and people don't really I have a lot of people who they get remarried and then they'll quitclaim their new spouse on, but they don't have it as joint tenancy, and it causes, I do find a lot in the estate planning process, and I point it out to them, and I'll say, if you guys didn't come to me and something happened, this right here on the deed, this is why you would have open probate. And they're like, what? The recording office didn't tell us that. I'm like, they don't know anything really from me. So anyway, they're very important. Liens and judgments play a huge part as well. So obviously, if you have when we pull ownership reports, we can see if you have a lien on your property. Most of them are mortgages, but every once in a while we'll see, oh, you have a lien from the water company for $60, and they're like, what? I didn't even know, and then they get it done. So we also we can see that too. Yes, did you have a question?
Oh no.
Okay. And then gifting strategies must be thought of too. Now, some people who are over tax thresholds and things like that always meet with an advisor and see the best way to lower whatever your taxable income is, and things that are above my pay grade. But meeting with advisors to talk about those things is very important as well. And then the conversations behind the documents are critical. So I think that people are getting more and more comfortable talking about estate plans and just death in general. Mm-hmm. I think it's like my grandparents probably, they were the quiet ones. They didn't want to talk to anybody about it, just leave it alone. I have a lot of clients, they say, my parents won't talk to me. They say they have a trust, or they say this, and I'm like, if they're not going to talk to you, that's unfortunate. You're going to find out a whole thing, all these things later on. But having the conversations is important. That's why we offer those family meetings. Hearing it from an attorney, we are very good at keeping the emotion out of everything, right? So if we talk to your family and say, this is just the way that it is, things get a little less emotional. It's when we're, which can be helpful. But it is important to say, are you comfortable being in this position? Would you be comfortable being the guardian of my child? Would you be comfortable being the trustee? because people need to know what their jobs would be and that they are the ones in charge. You don't want to overwhelm them with the job on top of surprising them that they were appointed, right? So making sure you feel comfortable enough to have the conversations with the people is important. Yes.
If so, let's say you have an executor, trustee, or whatever. What's it called? Personal
representative?
Yeah.
Yep.
So how much information of theirs would you need to say, hey, let's say it's a Steve Smith, and how many Steve Smiths are there out there? Like, how much, like, of their information? Do you need their social and all that other stuff?
No, we put their full name, so
Okay.
first, middle, last name, and we put their phone number, just
Okay.
as an easy contact information.
Okay.
Some estate planning attorneys do more. We don't feel comfortable putting people's socials in your document. It's just like, we don't need socials flying around everywhere. And then addresses, some of them do a lot of addresses. We don't do that because people move a lot. And then you have to keep coming back to me. Phone numbers seem to be the things that don't change as frequently.
Right.
Like I've had one phone number my entire life. So it seems to be the best way to just have that easy form of contact.
Got
I
it.
mean, she's young.
My mom and dad have also had the same phone number since they got a cell phone. So our ideal clients are people who have minor children, when you own multiple properties, when you need rules for distributions, and obviously business owners. But we have a lot of people come in who move to Colorado and they have a plan from another state and they want it reviewed. We do that. We have people who these don't pertain to them. Maybe they have one house and they have one child and they just want to make sure that everything's going to go to them easy peasy. They can come to us too, right? Really, everybody needs an estate plan. Something else that I'm seeing that's common is our clients coming back when their kids reach 18, because when your kids are 18, they are adults. So if something happens, God forbid, they're in college, they're driving, they're in the hospital, the doctors will not talk to you. You are no longer their guardian. So I do have a lot of clients coming back to get powers of attorney for their 18-year-olds, 19-year-olds before they go to college and things like that. So really anything on those lines, people can come to us. This just explains all the things that I've already explained. Minor children, right? It's imperative for families with minor children because we can't give them distributions until they've reached 18. Multiple property owners, we want to make sure that those properties are avoiding probate in all states. If you have LLCs or the rental properties, you want to make sure that those are properly owned by your LLC. The rules for distribution, and of course the business owners, we want to make sure your business documents have the proper language. A lot of business attorneys have the blessing of not thinking about death all day, which is great. You can get a really good governing document for your business from a business attorney, but it doesn't include the language that says where everything goes. It'll just kind of say to my heirs. That language triggers probate. So we want the specific language that references your trust, things like that. So I review business documents as well for clients, and just that one portion to see if it has that right language. And then working with an estate planning attorney now will help ensure your loved ones will enjoy the future you intended. What I like about this specific statement is that you should be working with an estate planning attorney. If your son-in-law or your brother is a personal injury attorney or a business attorney and they say, it's fine, I can just fill in all the things for your estate plan, could they? Yes. Could I help you with your personal injury case? Yeah. Should I? No. So, go to the people who know the ins and outs, and so there's no holes in your plan. And then just how to book. You can use that QR code, or you can use. There's our website is on my business card, or you can email me directly. But again, that initial consultation is free. The initial can be done in person or virtually. It's no longer Google Meet though; it's Teams. We just moved from Gmail to Outlook, so now we're Teams. But anyway, anything can be done virtually except the signing meeting. Are there any questions for me?
On a side note, I just wanted to let y'all know, like especially real estate agents, she has CE courses that we can schedule, and probably like after the first 3 years, so you guys can get some hours in. This is also just the adding value to your client and database as this information. Everyone's gonna pass away at some point, so it's just good information to pass along to add that added value or to deepen your relationship with your past clients. So that's actually how I met her.
Yeah.
So when you go through your firm, right, and then you're a client and you pay for the trust created, which comes with the will, right?
Yeah, so there, I didn't really talk about that, just briefly, just so you know. A trust comes with what's called a pour-over will. It's a very, very small will that just says, put everything into the name of my trust. So like, if you have a trust and everything's avoiding probate, but then you buy a new property and you don't buy it in your trust name, or you don't come to me to fix it and put it in your trust name, and then you die, that property will trigger a probate. And the pour-over will says, put it into the name of my trust. Okay. So it's just that, you still have to go through that whole probate process, but the distribution part says, put it into my trust, and then it's handled from there.
It's like catch
But yes, you get the will, and then it has the guardianship provision for the children, yes.
Okay, so when, let's say, you know, you sign and all that, and then years down the road, something changes, so we notify you, right?
Mhm.
Okay, there's this change, I just need to, what do? You advise. Is that something that's billed again?
If the question is not, if you make an amendment or if there is a change, yes, that's then all of this is a flat fee. Anything we change or amend later on is hourly because it ends up being nominal.
Got it.
Yeah, it's very easy for us to change our own documents.
Okay.
That's a good question. Anything else?
Tiffany, Heather, and myself, we typically do videos to help, be in front of people and reasons, and this is amazing, so
Yeah.
thank you
Oh,
for this.
great, yeah.
Are you okay if we do this, put this on our YouTube channel?
Let me just make sure with Kristen
Okay.
that she's fine with that. I don't know.
Okay.
But I'm fine with it. But let me just make sure, like, for our firm, it's fine.
Okay.
Otherwise, yeah.
Okay.
And then with the CE courses, we teach, I teach this essentially in two parts. I do one for realtors about how to get through the probate process, and that's about how if you're in the process of selling a home and the owner dies before closing.
Yeah.
And a probate's required. So I go through that, and then I talk about estate planning and how to avoid that. And then we also have a rental property and what's LLCs and estate planning. So I talk about that. That's a CE course, and then we just got a fourth one that is property deeds and estate planning. So the difference in deeds, trustee deeds, how it's owned, personal representatives deeds. I talk about all the deeds with realtors. So yeah, those are the CE courses. Anything else?
I do have another question.
Yeah.
It's more on the insurance side. So I heard you had said something about the liability, like when there's multiple LLCs, maybe doing it that way because it protects the liability, separately doing that, right?
Yep.
So what if there's 7 properties and there's 2 separate LLCs, and then they got an umbrella, obviously, that would need to be written in both of those LLCs because that's how the properties are written. Would that be something that would cover them? Because I heard you kept saying about, being protected on that liability aspect.
Are you saying?
And then the
if-
umbrellas, you
like-
can go all the way up to like 10 million or what have you. Is that
Yep. So what I'm talking about is some people
what you're referring to? Yeah.
Yeah, the most liability protection that you're afforded is if one rental is in its own individual LLC. These are all separate entities. So if we have 2 separate LLCs, one in each of them. If there's an accident on this rental property and the insurance coverage doesn't cover it,
Right.
they cannot go after this entity. So long as all of those formalities are met. That's why
Right.
there's liability protection. They can only go after what's here.
Right.
If we have 2 properties in one LLC and there's an accident on this property and the coverage doesn't go, they can go after this property.
Yeah.
So that's why I always say meet with a financial planner or advisor, insurance broker, whoever, to make sure you have adequate coverage
Sure.
on each property. And they can talk to you about, what's going, like people in Breckenridge who have rental properties in Breckenridge,
Yeah.
they probably need more than people in Florida, right?
Sure,
We have snow,
sure.
we have things, so I don't know, I'm just guessing, because again, I'm not an insurance
Okay.
agent, but they'll be the ones to talk to you, make sure you have adequate coverage based on however the LLC is set up. But that's why when I have clients who they say, well, my CPA told me to get 5 LLCs for each of my rental properties, and I tell them all the formalities, and they say, well, I don't want to do all that, then I go, then don't do that, because
Right.
then it's going to pierce that corporate veil, and not only can they go after other business assets, they can go after your personal assets. So
Okay.
that's why it's important knowing all the things that encompass the liability protection of an LLC.
Good question.
Anything else?
That was really good.
Okay,
Yeah.
great.
Cool, thank you.
Yeah.
Thanks for-
Yeah, that